Yes, good morning.
Good morning. May it please the Court. My name is Charles Waters.
You may want to wait for the clock to start. There.
May it please the Court. Good morning. My name is Charles Waters, and I represent the plaintiffs' appellants in this case, including Patricia Pietropalo, who is the elderly widow seeking the death benefits of a life insurance policy promised to her late husband. This case was filed originally in July of 2004. It went to trial in July of 2009. The jury came back with an award and a finding of negligence against both defendants, Defendant McMenimen and Defendant Armstrong. It also came back with a finding against Mr. McMenimen for misrepresentation. The court then held for itself the 93A claim, and in July of 2009, the trial court entered judgment against McMenimen under 93A, triple damages, and awarded certain attorney's fees. The court then dismissed the 93A claim against Armstrong. We come, the plaintiffs do, before this court asking for generally three areas for this court to look at. Specifically, one concerning Nationwide. Nationwide was dismissed pursuant to a motion for judgment on the pleadings by the trial court, pursuant to what we believe was an erroneous construction of General Laws, Chapter 175, Section 181. The second area is against Defendant McMenimen. We believe that the court erred in not awarding all attorney's fees pursuant to 93A that were requested. The third area of relief we're looking from this court is relating to Defendant Armstrong. We believe that the court should have, but did not, enter joint and several liability against Armstrong and McMenimen, as well as the court should not have dismissed the claims, the 93A claims, and this court should vacate the dismissal and remand for further findings.
Can I ask you a question with respect to Nationwide? Let's go up to the top. There has now been a jury finding in a case in which you participated that the plaintiffs knew or reasonably should have known by July 1, I'm not sure of the exact date, but more than 3 years before the lawsuit was filed, of the underlying facts, the fact that they hadn't purchased the $500,000 policy. Doesn't that knock you out? Doesn't matter?
It doesn't, Your Honor.
Why doesn't it knock you out? 3 years statute of limitations?
Your Honor, because the first question that the jury answered triggered the General Laws, Chapter 260, Section 12. Specifically, they found fraudulent concealment.
Well, they found fraudulent concealment by McMenimen.
That's correct, Your Honor.
And when did McMenimen leave the employ of Nationwide?
Your Honor, I believe that was in 1999, but during all of the relevant period of fact, he was an agent of Nationwide.
I'm sorry.
He was an agent of Nationwide during all of the significant misrepresentation, all during the negligence, and all during the time when the court found 93A.
And you're suggesting that this would be a finding that would apply equally to Nationwide if they were in the case?
Yes, Your Honor, for two reasons.
Because he was their agent?
Excuse me?
Because he was their agent?
That's one of the reasons, Your Honor. And it really comes down to what this jurisdiction, Massachusetts, how it's interpreted its own fraudulent concealment doctrine. This jurisdiction, Massachusetts, has interpreted its fraudulent concealment doctrine broader than the other jurisdictions. Specifically, in Demoulas, it referred to the broadening of the fraudulent concealment doctrine, and specifically this court in Demoulas held that the fraudulent concealment of key defendants was sufficient to toll the running of the statute of limitations for other defendants.
But, you know, Nationwide, I mean, there's just no evidence at all that Nationwide was doing anything other than sending on the correct statements and correct information to the plaintiffs.
That's actually not accurate, Your Honor, and there's a bunch of evidence that was admitted into the trial that suggests just the opposite. In fact, Nationwide had documents, applications, that everybody concedes were forged applications.
Wait.
They have in their possession.
No. I'm talking about the information from Nationwide to the plaintiffs repeatedly, year in and year out, was accurate information. And it was McMenimen who was saying, oh, pay no attention to what Nationwide is saying. That's not true. It's not accurate.
That's correct.
Yeah.
Nationwide sent materials to the plaintiffs via the statements. Yeah. Now, those statements read $200,000 base policy, but they also said option plus. And you also had McMenimen, who was the agent for Nationwide, saying to them, well, there's a second component to it. and there's a what McMenimen called a dump-in. And he explained it very convincingly to them, that this dump-in was this cash surrender value of the John Hancock policy that would then purchase additional insurance in the second component of the life insurance policy. And so that there were two components. There was the first component, which was the base, and then there was this $30,000 dump-in that would continually buy insurance, and that at the end would add up to $500,000 of death benefits. So, Your Honor, Justice Cordy, getting back to your question, it's true that Nationwide didn't send forged documents to them. They sent the statements to them. But what Nationwide is on the hook for is, for example, knowing that McMenimen was forging documents. They had those documents in possession. Knowing that...
knowing McMenimen was forging what documents?
There's an application, Your Honor.
Back in 1996?
There's an application in October of 1998 that what McMenimen did was he took the March 1998 application and he took the signature lines and he transposed those signature lines onto an October 1998 application and submitted it into Nationwide. And we know
Nationwide knew that.
We know that because Nationwide then, 2 days later, sent another application, so it did not accept the application in its possession, presumably because it was a forgery.
So then it got real signatures.
So then they did get real signatures through their agent who was continuing misrepresentation. But there's an equally, I think, significant point, Your Honor, and that is that Nationwide also knew there was an existing money policy. There was an existing $350,000 money policy, and Nationwide knew it. How we know that is we know that because...
This is in the 1990s. We're not talking about conduct that would have extended the statute of limitations beyond. What did the jury find? July 1 of what? 2004? Or 2001?
2001, Your Honor. Okay. Yes. This is conduct in 1998. So in 1998, when the insured had $500,000
But the jury found that by July 1 of 2001, your clients knew or should have known what their policies actually provided from Nationwide.
They found that, but the fraudulent concealment doctrine tolls the running of the statute of limitations.
I know, but the fraudulent concealment took place after that, right?
But Your Honor, respectfully, no.
No?
Respectfully, the fraudulent...
But if they should have known as of this date, I thought the fraudulent concealment was Mr. McMenimen's continuing to lie about the situation after 2001.
Your Honor, that fraudulent concealment happened beginning in March of 1998 when the application was originally filed with Provident Mutual, which, by the way, is now Nationwide. So it was originally filed, the application, in March 1998. The hiding of the fraud happened almost immediately after, and there were several sequence of events, including in the application, they didn't check off the replacement box. That's very significant because in the application, when you don't check off the replacement box...
This all has to do with the original policy, not,
that's right.
Not the fraudulent. I don't understand this fraudulent concealment piece. Maybe I just don't understand it.
Well,
how it extends. Does it extend the statute of limitation forever?
No, not forever, Your Honor. It extended until they found out in April of 2003. They got a phone call from somebody, an agent from NEAG, which is an agency that Defendant Armstrong set up, and they got a phone call saying that your policy has been orphaned. And that's when they first were on notice of potential fraudulent concealment of the cause of action.
Well, then what does it mean for the jury to say that they knew or should have known as of July 1, 2001, that they didn't have what they thought they had?
Because what the jury did is the jury took into consideration that they were getting these statements. And the jury considered getting those statements, reading those statements, and those statements in and of themselves do suggest there's only a $200,000 policy. But what was going on was that Mr. McMenimen, who was a fiduciary, was telling them something else. He was telling them this is statements for the $200,000 base, but not the $500,000 policy. And the jury believed that. And the jury believed he was a... Yes, Your Honor.
A fiduciary, not because he was an agent of Nationwide, but because he was a family member of, and giving, investment advice, personal investment advice to the family. That made him a fiduciary.
That's right. But when you look at Demoulas, you say if the fiduciary has fraudulently concealed, the cause of action, and that fiduciary is a key defendant, then you toll the statute of limitations for all defendants. And that's what this jurisdiction says. Other jurisdictions don't take such a broad approach. Other jurisdictions, as cited in our brief and cited in defendants' briefs, take a more limited approach. But, and it's important to understand, even that limited approach still has an exception for the agency principal relationship. So even those jurisdictions that are more limited, those courts say you don't want the fraudulently concealing defendant does not toll for other defendants except if there's an agency relationship. And in this case, there was an agency relationship. So, Your Honor, to get back to...
Did anybody find an agency relationship? Did the jury find an agency relationship?
Your Honor, that question was pled in the complaint. Nationwide was then dismissed on a motion for judgment of pleadings.
So there was no jury finding
so
as to this?
there was no issue in front of the jury.
So does it have to be remanded if that's the basis?
Yeah, I think there needs to be a remand with, I think, a narrow scope. And that scope will be, was he an agent and was he acting within the scope of his agency? And I think those two are the two issues that do need to be remanded relating to Nationwide.
In Demoulas, were all the defendants fiduciaries?
No, they weren't. Only some of them were fiduciaries. The officers and directors of the corporation were fiduciaries, but there were other defendants that were not. And that's why Demoulas really does apply here, because you have at least one fiduciary, which across the board, everybody concedes, although not explicitly, but it concedes that McMenimen, because of the circumstances, was a fiduciary. So that's why Demoulas does apply here, because it's the fiduciary who is the key witness that Demoulas looks at. Just like the officers and directors in Demoulas that were taking their siblings to their attorneys to have them sign documents, here it was McMenimen, who was their family member, who was telling them, you have a $500,000 policy, trust me, I'm looking after you and your father, I'm looking after, my family. And they trusted him. And that relationship, that fiduciary relationship, then tolls the running of the statute of limitations for other defendants. And it makes sense that it does. Because at the end of the day, this court needs to decide whether or not to allow the defendants to assert their statute of limitations defense. And it's an equitable analysis. And it would not be equitable to allow the defendants who prosper financially from this sale of a life insurance policy that was sold to them under false pretenses by McMenimen. It would be unfair to allow them to prosper on that sale and allow them to walk away claiming a statute of limitations defense, which is why it's certainly equitable that this court not allow them to assert the statute of limitations
Now,
defense.
is the statute as to Nationwide a statute of limitations or a statute of repose?
You're referring to the section 181, Your Honor?
Yes.
181, it's a statute of limitations. And we believe there's good reason for that. And I can certainly go into if that's...
If it were a statute of repose, don't we have case law that says that fraudulent concealment does not toll the statute of repose?
I don't think there's case law that says fraudulent concealment. I think there's case law that says generally you cannot toll a statute of repose. But this court specifically has never analyzed whether there can be a tolling of the statute of repose in the context of fraudulent concealment. We do cite a case, and I think it's in Illinois, we do cite a case in our brief from the Illinois' highest court that says that it in fact would be inequitable to not to toll a statute of repose in the context of fraudulent concealment. Said differently, fraudulent concealment does toll the statute of repose. This court hasn't ruled on that issue, but it doesn't need to, because this is not a statute of limitations. And I think more importantly...
Not a statute of repose.
Sorry, this is not a statute of repose. It is a statute of limitations. But I think more importantly, this is not a statute that this court even needs to get to decide what that time limitation really is, because the plaintiffs have not brought a claim pursuant to this statute. Their claim does not ask for a right of rescission. The plaintiffs do not ask to cancel the policy. The plaintiffs don't ask for their premiums back. All of those reasons are undisputed in this case. The plaintiffs have not artfully pled around this statute because that's not what they're looking for. That's not the relief they're looking for. So this statute isn't even in play. Now, the defendants say, oh, yes, it is, because what this statute really means is all actions arising out of a misrepresentation, any misrepresentation by an agent shall be limited to the recovery of premiums. That's how they want this statute to read. But when you actually read the statute, it doesn't say that, and it's not even close. The statute actually reads, the insureds may recover. May recover. It's permissive language. This is not a situation where it's the sole remedy. In fact, it's a situation where the court said, let's make this, or I'm sorry, the legislature said, let's make this real easy for the insureds. Rather than having to sue the agent who told them the misrepresentation and have the agent dispute with the insurance company about the premiums and the commission, we're just going to give the insureds a right under this statute, an option. And that option is, hey, insurance companies, you're on the hook. If they want to cancel, you give them the premiums back. That's all it says. And in this case, it doesn't apply because we haven't asked for that relief.
Thank you, sir.
Thank you, Your Honor.
Good morning, Your Honors. My name is Harvey Walkoff. I'm appearing here on behalf of Nationwide. Nationwide submits, Your Honors, that Judge Van Gestel was correct in holding that Chapter 175, Section 181 is a statute of repose. But even if that were not so, even if Section 181 were a statute of limitations, plaintiff's claims would still be barred. And we make that argument on the basis of what Justice Cordy has already alluded to, which is that there was a trial. Judge Hinkle below gave a special question to the jury, and the specific design of that question, she said it in her instructions to the jury at page 3396, was to deal with this entire issue of fraudulent concealment and statute of limitations. And
it's not just the statute of limitations under 175, Section 181 that your argument goes to. It's the general.
Correct. And Justice Lank, the plaintiffs never argued below a different statute. The statute that they argued was Section 181. They never argued a different one.
But even if it is, I'm taking your argument to mean that the general tort statute of limitations.
That's correct, Your Honor. The 3-year statute of limitations would apply. The jury finding was that the plaintiff should have known as of July 1, 2001, under Section 181, that would be 2 years. The case should have been brought by June 30th, 2003, under the general tort statute, Chapter 260, Section 2A, 3 years.
Wouldn't you still have a problem under 93A, though?
The plaintiff, Your Honor, never pled Chapter 93. Strike never pled, never argued that the statute of limitations with regard to Chapter 93A applied. And we would cite, Your Honor, the trilogy of cases, the Grandi case, Slingsby case, Logadici case, which says...
Well, wait a minute. Aren't they all just appellate division cases?
Aren't they all what, Your Honor?
Appellate division cases. There's nothing... They're not controlling case law.
The Logadici case, actually, Your Honor, is a First Circuit case.
Applying Massachusetts law?
Applying Massachusetts law, and essentially held you have to look to the gist of the claims.
But we're not bound by those cases.
You're not bound by those cases. But those cases, Your Honor, are correctly decided. Hendrickson is a Supreme Judicial Court case, 1978, I believe, and that says that you look to the gist of the claims. The gist of the claim here was that there was a misrepresentation in connection with the policy. And, you know, the plaintiff never argued any different statute, and you'd be hard-pressed to look through their brief now and find any different statute. Another thing, this argument about fiduciary. The plaintiff never argued below before Judge Van Gestel, as was argued, for example, in Wilson Farm, which is a Superior Court case, but nonetheless was argued there. You can't apply the statute of repose because there's a fiduciary involved. Well, the plaintiff never argued that Nationwide was a fiduciary, and in fact, Judge Hinkle gave an instruction to the jury that the reason why McMenimen was a fiduciary was because he was a nephew and he was a close relative, and they relied upon him for that. She specifically said to the jury, it's not because he was an agent, an insurance agent, an agent of Nationwide. There was no objection to that.
But I think the argument is based on the fact that he was a nephew. Because he was a fiduciary, it follows that the entity for which he is an agent is bound as well. I don't think it's an argument that it's based on the fact that he's an insurance agent.
He's not a fiduciary with regard to Nationwide. Demoulas is inapposite because in Demoulas, the directors and officers are fiduciaries of the company. They're representing the company as fiduciaries. Nationwide just had Mr. McMenimen, and by the way, only until 1999, so the fraudulent concealment that's being discussed happened way after, and way after the jury's determination. But in Demoulas, you're talking about fiduciaries of the company. Here, you're talking about a fiduciary who's a nephew.
Mr. Waters is suggesting that in Demoulas, so long as at least one of them is a fiduciary, then all of the defendants are hooked by the fiduciary's actions. Do you agree with that?
No, Your Honor. If you have fiduciaries acting on behalf of the company, they're the company's fiduciaries. The company can be hooked. But Nationwide didn't have Mr. McMenimen as Nationwide's fiduciary. He was a fiduciary only because of his familial relationship with the plaintiffs. What Nationwide did, Your Honor, was it sent quarterly statements, not to the ultimately deceased alone, but to the trustee here, Mr. Passatempo, who's not only a trustee, but who's a lawyer. And on those quarterly statements, every quarter, it said death benefit, $200,000.
You're going to have to leave it there.
Can I ask a few more questions? I'm sorry, Chief. Do you mind? No, no. You say that he was no longer, did you say he was no longer an agent as of 1999? I'm trying to figure this out.
Yes, Your Honor.
What do you mean by that?
He left.
Left the company, but did he remain an agent for?
No, he was no longer an agent of Nationwide after 1999.
Okay, well then why?
He could not bind insurance. He could not write insurance. He wasn't representing Nationwide.
How come the plaintiff
That's
says he was? I'm confused. What does the plaintiff point to, as far as you know, as to why he continued to be an agent in some fashion?
Your Honor, I know of nothing.
All right. One more question. I apologize. So this fraudulent concealment finding related to conduct after 2001, or?
I don't know that the record is clear, Your Honor, but even if there were fraudulent concealment, the jury's answer to the special question that Judge Hinkle gave specifically to deal with the issue of the statute of limitations said, whatever the fraudulent concealment, there were these quarterly statements going out. By July 1, 2001, you either knew or reasonably should have known. The trustee was getting them. It was the trustee, a lawyer, getting these quarterly statements. So any fraudulent concealment, the tolling ended as of July 1, 2001. That date was specifically selected by Judge Hinkle because the case wasn't filed within 3 years. And as Justice Lang pointed out, even if we're talking about the general statute of limitations, Chapter 260, Section 2A, the case is time barred.
Thank you.
Thank you.
Okay, thank you.
Good morning. May it please the Court, my name is Tim Egan, and I represent Defendant Barry Armstrong. I'd like to touch upon two issues. There are several issues floating back and forth, both by and against Mr. Armstrong, but I'd like to focus on...
Several? You're being kind. Several issues?
Yes. The statute of limitations I'd like to focus on, and also the joint and several liability. The statute of limitations and the fraudulent concealment we've touched on, and I'd like to talk about how it applies to Mr. Armstrong. There is no evidence that Mr. Armstrong fraudulently concealed in this case. Judge Hinkle below stated she would not even let that issue go to the jury because there was nothing to support it. There's no evidence Mr. Armstrong actually participated, knew of, or condoned any of the fraudulent conduct of Mr. McMenimen. The allegations are that he was responsible for supervising Mr. Armstrong, and that he somehow failed to supervise and he failed to detect what Mr. McMenimen was up to with respect to his family members. As such, the fraudulent concealment tolling doesn't apply to Mr. Armstrong. The jury came back clearly and found that as of July 1st, 2001, the plaintiff should have known in the exercise of ordinary diligence that they had been harmed. And so Mr. Armstrong is entitled to a finding that he is that applies to him and that the statute of limitations is run as to him. The plaintiff suggests in response that somehow it should be told as to all defendants because there is just because there is fiduciary, and that is not correct as a matter of law in Massachusetts and beyond. Based upon that reading, it would be so expansive that there would be nothing left of statute of limitations because someone in Mr. Armstrong's position had no knowledge of the fraudulent concealment or even of his alleged negligence for years. And it was only because Mr. McMenimen, unbeknownst to him, had been keeping it from the plaintiffs. The purpose of unlike the discovery rule, which is to protect to plaintiffs, the purpose of the fraudulent concealment doctrine is to punish fraudulent concealers. It is to make sure that a fraudulent concealer does not benefit by his or her misconduct. That does not mean that someone in Mr. Armstrong, who may have been negligent but was not acting in any malicious way nor knew of the concealment, should be punished and bound by that. Otherwise, there would be no statute of limitations for anyone, even an innocent defendant who did not fraudulently conceal and had no knowledge of it. It could be years and years before it could ever come to light that he might be liable.
But Judge Hinkle allowed the claims to go against your client to go to the jury and wasn't persuaded, I guess, that the statute of limitations barred the claims.
The judge let all of the issues go to the jury and specifically asked the question, should the plaintiffs have known as of July 1st, and did they have actual knowledge? In response to the jury's findings, the judge decided that Armstrong was liable based upon his negligently failing to deliver the policy. And I would suggest to you that this was an error on the part of the trial court because negligence in and of itself is not a basis for tolling the statute based on a fraudulent concealment theory. And that's the only theory that really applies here. So that is the error of law for which we cite in our brief and the reason that we're an appellant for those purposes.
Well, let me understand something. Did you ask the judge to enter judgment on your behalf because of that specific finding by the jury?
We did, Your Honor.
And she denied your motion?
She denied that motion. Right, okay. And in the margin, on just that basis, that one sentence,
yep,
that the negligence was the basis. As I see my time is short, touching quickly on joint and several liability, the jury made specific findings, was asked a simple question, was Armstrong negligent, and if so, what's the monetary value of the negligence he caused? They came back with a specific finding based on specific instructions, and there's nothing to indicate, as the plaintiffs would have the court do, that was somehow inappropriate and that we should go back and try to reinterpret what the jury meant and that they were really trying to find joint and several liability when it had been consistently and repeatedly denied by Judge Hinkle. As a matter of law, she said that this was not a joint and several liability case. She asked the plaintiff to cite cases from Massachusetts to support its position that it was. The plaintiffs could not do so, and they don't do so in their brief. And in fact, the second case they cite, the Sullivan case, actually, we believe, supports our position that there was no joint and several liability. There were two aspects of this transaction. There was the loss of the money policy, and then there was the loss of the New York Life policies, and there's separate harms. And I see my time is up unless there are questions. Thank you.
Good morning, and may it please the Court. I'm William Corbett, and I'm here again for Frederick McMenimen. I'd like to begin by touching upon some of the points that were made by Mr. Waters in his presentation. First of all, and I think it's very important because it may allow some of the statutory construction issues as to Chapter 93A and Section 181 of Chapter 175 to be bypassed. The fraudulent concealment that was proved at trial, at least according to the jury's finding, is conduct that took place after 2003, after the statute of limitations had already run. What the plaintiff has done, persuasively, has been to conflate the initial fraud that took place in 1998 and the conduct that allegedly took place in 2003 and 2004 after someone from Nationwide or someone from any AG called the plaintiffs to let them know that the policy had been orphaned. But in the meantime, there's no specific evidence of any representations that were made by Mr. McMenimen, any questions put to Mr. McMenimen concerning the substance of the policy. No questions as to why the statements that were being sent to the plaintiffs on a periodic basis were saying that there's only $200,000 by way of a death benefit with no other coverage.
Even if that's so, you still have the 93A problem, don't you?
For several reasons, no, Your Honor. First of all, Chapter 93A does not apply in this situation. If you look at the...
Because?
Because when the legislature amended Chapter 93A in response to the Dodd case, it expanded the scope of the Section 9 right of action to reach people who had suffered a loss of money or property and not just people who were in privity with the defendant. But what it did in the insurance context was to say that if alleged misconduct violates Clause 9 of Section 3 of Chapter 176D, it's actionable. Other aspects of Section 3 of Chapter 176D are not included in that reference. Now, the legislature would not have put that specific reference to Clause 9 of Section 3 of Chapter 176D into the amended Chapter 93A if it hadn't meant to limit the right of action in the insurance context to unfair claim settlement practices. This claim would arise under Clause 1 of Section 3. Now, there's been some talk to the discussion of two prongs of the right of action under Chapter 93A, Section 9, and the court made reference to it last year in a dictum in Wheatley, talking about how there's the first part that refers to violations of Section 2 of Chapter 93A, and then there's the subsidiary violations of Clause 9 of Section 3 of Chapter 176D, which is incorporated by reference into that cause of action. Now, if there were truly two prongs and that they were separate avenues for asserting a private right of action under that statute, the second prong would be surplusage, because if you look at how Section 2 of Chapter 93A and Section 3 of Chapter 176D are written, they both use the same language. They both describe unfair and deceptive acts or practices, and Section 2 of 93A refers to trade and commerce in general. Section 3 of Chapter 176D refers to a specific type of trade or commerce, the business of insurance. The second putative prong, the violations of Clause 9 of Section 3 of Chapter 176D, is a subset of the first prong. Anything that violates Section 3 of Chapter 176D, by definition, is a violation of Section 2 of Chapter 93A. If the legislature had intended otherwise, if the legislature had intended that all unfair and deceptive practices in the business of insurance would be actionable under the private right of action in Section 9, it didn't need to have the reference to Clause 9 of Section 3, because everything that violates that statute would violate Section 2 of Chapter 93A. I'd like to touch upon a few points that were made also. There was no concession made that Mr. McMenimen was the plaintiff's fiduciary. In fact, the plaintiffs dropped their breach of fiduciary duty claim before resting their case, and we did not, in reliance on that, we didn't put on our countervailing evidence that he was not a fiduciary because it was res judicata. The stipulation of dismissal operated as a judgment. It precluded the allegations, the claims based upon the breach of fiduciary duty. And all they're trying to do now with using the putative breach of fiduciary duty to trigger the actual knowledge standard for the statute of limitations calculation is to circumvent the dismissal of their breach of fiduciary duty claim, but in effect recover for that self-same breach of fiduciary duty. I see that my time's up, so if the court doesn't have any further questions, I'll submit on my briefs. Thank you.